Okay, the Honorable Court was tasked with the determination of two applications. The first one is one dated the 30th of September 2024, which was filed by the plaintiff's applicant herein, while the second one is dated the 6th of October 2024 by Base Titanium Kenya Limited and defendants herein. The defendant's application, so let me start with the plaintiff's application. That is, that application sought to have the following order. The one by the plaintiffs sought for the following orders, that they be granted temporary injunctive orders, awaiting the outcome of this. So it was brought basically under Order 40. It is supported by the affidavit of Masyuki Mutisia. The second application by the defendant, that is premised upon the provisions of Order 2, Rule 15.1a and 15.1 and d, and Order 4, Rule 1.3 and 1, Sub-Rule 6, and Order 4, Rule 3 and Order 51 of the Civil Procedure Rules of 2010. Basically, the defendants, there is also the grounds of opposition responding to that application filed by the defendants. And I've also seen there's a preliminary objection also raised by the defendants that is dated the 31st of January 2025. And basically the preliminary objection is challenging the jurisdiction of this Honorable Court in hearing and determining this matter pursuant to the provisions of sections 153, 154, and 155 of the Mining Act of 2016. It's also stating that the plaint contravenes the mandatory provisions of Order 4, Rule 3 of the Civil Procedure Rules. The Honorable Court has no subject matter over which it can exercise jurisdiction, and consequently, any order will be granted in vain in view of the Court of Appeal decision, civil case number 92 of 2008, Anthony Gashara Ayub versus Francis Mahinda Bigwa. Likewise, the plaintiffs have also filed. They have challenged the preliminary objection through the grounds of opposition dated the 7th of February 2015. I've raised quite a number of issues there, which I will not want to deliberate on in detail. The notice of motion application dated the 6th of December 2024 by the defendant seeks the orders that the plaint dated the 30th of September 2024 be struck out, and I think I've given the reason thereof, and then the cost of the same. Both parties have also filed their submissions, and the court has had an opportunity to deliberate on the submissions in depth, and the authorities that have been cited. The court has framed the following issues for deliberation: whether the preliminary objection has met the legal threshold based on law and the precedents, and whether this Honorable Court has jurisdiction to entertain instant suit and application, whether the suit has any merit, whether the applications have met the threshold of warrant granting injunctive orders pursuant to the provisions of Order 40 of the Civil Procedure Rules, and who is going to bear the cost of this suit. Upon deliberation of all the issues that I have framed out in depth, the Honorable Court has arrived at the following decision. Number one, that the preliminary objection dated the 31st of January 2025 be and is hereby dismissed for lack of merit. That the notice of motion application dated the 30th of September 2024 by the plaintiffs be and is hereby found to have merit, and therefore it's allowed. In essence, the Honorable Court proceeds on to grant injunctive orders as sought from that application. That the notice of motion application dated the 6th of December 2024 by the defendant be and is hereby found to lack merit, and therefore it's dismissed. The cost of both the preliminary objection and the application is awarded to the plaintiff. Having said this is a matter that should now proceed on to for hearing. We need to get a mention date for pre-trial. Let us have a date for pre-trial, and if possible, you can have a date for hearing. Those are my orders. And parties are entitled to getting a copy of this ruling as early as Monday. You have it ready. So mention on which date we mention it, Mr. DC. We mentioned the matter on the 25th of June, and the hearing by consensus when we hear them, and then we hearing on 29th of October. Is that okay with you? Notwithstanding if there is any appeal to be filed and so forth, but we stand. Those are the orders. Is it okay? Physically?
Yes,
29th of October physically.
Most obliged.
Have a good day.